First of all, let me welcome everybody to the second webinar in Conn Maciel Carey's OSHA Webinar Series 2016. I'm so pleased that so many of you have come back to join us for the second webinar because the first one turned into a feature-length film. And Lindsay, who's joining me today, has promised to not talk as long as she did last time, to keep this to a reasonable length. But I guess I'm sure all of those of you who know me know that it was probably my fault that we ran so long last month. But this month's webinar, we're going to be talking about OSHA's new fatality and injury reporting rule. And I keep sort of characterizing this as a new reporting rule. It's not really a new rule. In fact, we are 1 year into an amended rule for a rule that's been around for a long, long time. But there was a major change at the start of 2015, and we have learned an awful lot about it over the course of the last year as it's been implemented. So we thought it would be a good time to get everybody together and talk about what we've learned from the first year of the new reporting rule, and that's what we're going to cover today. The faceless voices that you're going to hear during this webinar, I'm Eric Conn, one of the founding partners of Conn Maciel Carey, and I chair the firm's National Workplace Safety Practice Group. I'm an OSHA defense attorney by trade. I'm excited to share the news, if you didn't see it, that we have added MSHA expertise to our workplace safety practice just over the last couple of weeks. So rather than just characterizing ourselves as an OSHA practice group, we're the workplace safety practice with specialists in OSHA and mine safety issues as well. My practice, though, focuses primarily on occupational safety and health law, representing employers in inspections, investigations, and enforcement actions involving OSHA, the U.S. Chemical Safety Board, state OSHA programs, a little bit of MSHA, and Environmental Protection Agency actions where there is overlap with worker safety issues. I work with my clients on also on all aspects of litigation against OSHA, including criminal matters, contests of OSHA citations, and often with a focus to settle OSHA citation cases in a way that has minimal or allows those citations to minimally affect civil actions, personal injury, wrongful death suits, or the company's ongoing operations. I'm joined today by my colleague Lindsay Smith, who is also a OSHA, but also an employment and labor expert. I'll let her introduce herself here.
Good afternoon, everyone. Like Eric said, my name is Lindsay Smith, and I'm an associate here at Conn Maciel in both the OSHA practice and the employment and labor practice. My practice on the OSHA side basically consists of supporting Eric's practice. I also work with him to defend citations, assist with inspections, give advice on how to handle a whole slew of different types of OSHA issues. And then also, helping to develop and audit safety and health programs for our clients.
All right. So what are we going to be talking about today? We are going to review, if hopefully you already are fairly well versed in the new reporting rule because it has been in effect for a year, at least in the federal OSHA states. We're going to review some of the requirements of the reporting rule and really some of the nuances that we've picked up over the course of the year, things that might on their face seem like they're reportable based on the way the rule has been discussed and described publicly, but which turn out to not be reportable when you dig into the nuances of the reporting requirements. So we'll dig into that. We have received from OSHA a fair amount of interesting data about what has been reported and what industries reports are coming from most often. And then I'm sure what's of most interest to you all is what OSHA is doing with those reports. Are these triggering enforcement inspections? Are they triggering other touches with the agency? And we'll talk a little bit about what happens sort of after you report to OSHA, what you can expect. And then in relatively recent news, OSHA has finally launched this online reporting portal. So we'll talk a little bit about what that means and what you ought to be doing or not doing with that portal going forward. And then at the end of the discussion, we've got a couple of ideas and best practices that we want to share with you about how to determine something is reportable, how to make the report, and then how to handle some of those activities that you might encounter after you've made a report to OSHA. So let's jump right in and talk about the rule itself. OSHA has had a reporting requirement as part of the OSHA Act really since the agency was born. The original reporting requirements were that within 48 hours of certain types of incidents, you had to either pick up the phone and call the local area office or use the telegraph to report to OSHA these incidents. That tells you how far back this rule goes. I'm pretty sure I couldn't pick a telegraph out of a row of old electronic equipment, but that was the original reporting methodology. And what it is that had to be reported back in 1971 when the rule was first enacted was all employee fatalities, work-related fatalities, as well as a single incident that resulted in the overnight hospitalization of 5 or more employees. And that was, it turned out, after the rule was promulgated, to be an extraordinarily rare circumstance, that one incident causes 5 or more employees to go to the hospital. It was tended to be your very significant chemical incident or petroleum refinery explosion events, maybe a very big construction collapse incident. But other than that, it was very, very rare that there would be a single event that caused 5 or more hospitalizations. So, nearly 25 years later, OSHA decided that they would amend their rule to try and sweep in more events to become reportable, as well as modernizing a little bit the methods for reporting. So in 1994, OSHA changed from a fatality and hospitalization of 5 employees to a fatality and hospitalization of 3 or more employees became a reportable event, and they also felt like they weren't hearing about and getting access to workplaces quickly enough after these significant events. So they lowered the amount of time that employers had to report serious workplace incidents to OSHA from 48 hours to 8 hours. And they also introduced a new 24-hour hotline, reporting hotline, 1-800-something-something OSHA is their 24-hour hotline. So you could pick up the phone, call them not only at the area office, but at this generic number and reach someone at all times. So, 20, 25 years pass again, and OSHA looks at their, the data around injury and fatality reporting and realizes that they're still not getting that many reportable events, even after lowering it from a hospitalization of 5 employees to 3 employees. And what we saw is, an average of anywhere from maybe 5 to a dozen events that meet that. It was the catastrophe definition, 3 or more hospitalizations. That it was still extremely rare. Never really more than a dozen or so a year of those events that result in a hospitalization of 3 or more employees from a single event. So OSHA, in a pretty dramatic change, lowers in this new rule that was rolled out 2013, became the law in 2014, and became effective on January 1st, 2015. Still fatalities are reportable. Still fatalities are reportable within 8 hours, but instead of the hospitalization of 3 or more employees, there are now reportable events that involve the hospitalization of a single employee, as well as introducing 2 specific categories of injuries that OSHA wants to make sure they hear about, regardless of whether they result in hospitalization, and those are amputations and the loss of an eye. And these 3, call it the 3 new categories, the single hospitalization, the amputation, and the loss of an eye, become reportable within 24 hours as opposed to 8 hours under the new rule. And one other new change under the new rule is, in addition to the telephone reporting option, calling the area office or calling the 1-800 number, OSHA announced when the rule became effective that there would be this web portal where you could go on your smartphone or go on your computer and type in the information that's required to be reported and share the information with OSHA that way. And that was a coming soon web portal for more than a year with the rule in effect. And just in the last few weeks, OSHA finally rolled out that web portal. It is live on their website now, and we'll talk a little bit about that web portal today. So the impact of this new rule, it became effective in the federal OSHA states on January 1st, 2015. So we have 1 calendar year in the books and a month or so of experience with the rule to talk about today. An interesting element of the rule is it became mandatory for the state OSHA programs to adopt this rule or a rule that is at least as effective. Just like everything else in the state OSHA programs, you are required to be at least as effective as federal OSHA. So if you don't have a reporting rule that already requires, in a state, requires the reporting of a single hospitalization, all amputations, and all losses of an eye, those states need to change their rules, change their reporting rules to conform with that. What was interesting about the rollout here is this January 1st, 2015 date was the date for federal OSHA. It was not the date for almost all of the state program states. Although they're required to adopt it, they are not required to adopt it as of January 1st, 2015. And the reason is, like federal OSHA that has to go through notice and comment rulemaking, the states have similar protocols to introduce new rules and requirements in their states, whether it's a regulatory process like notice and comment rulemaking or a legislative process like many of the states have. That takes time, and although it's mandatory to adopt such a rule, OSHA recognized that the states might require a little bit of extra time. So this is an important thing to think about if you're operating in one of the state program states, is before you pick up the phone and call, double check that your state has actually adopted the new reporting requirements, and also check what the historical reporting requirements were in your state. We've got a question here that asks, is the reporting requirements the same in California as it is under this new rule? My understanding is that California has not adjusted its historical reporting rule, and I'm not sure that they're going to, because their original reporting rule was already more or less encompasses everything that the federal rule encompasses. You know, serious injuries were covered, and serious injuries involve hospitalizations, and they involve permanent disfigurement. So most likely that sweeps in all of the amputation and loss of an eye types of injuries that we're dealing with there in federal OSHA. So I don't think California has changed. I'm not sure they're going to, but we have watched many of the other states start to implement the rule, and others that are still a good ways away from adopting that rule. And we've seen a few instances where a report was about to be made by one of our clients. We dug into it and said, wait a second, this case involves the hospitalization of 2 employees, and this state plan has not changed from the 3-employee hospitalization to the 1 hospitalization rule yet, so you don't have an obligation to make this report. So you definitely want to check what the status is of your state before you do that. Always feel free to call us. We've got a little chart here where we're trying to keep track of where the states are. We double check that in each instance, but it's something to pay attention to and to watch out for. The agency anticipated, based on sort of extrapolating data from their annual BLS survey and the historical reporting data that they did get, and other factors, OSHA anticipated that by lowering the requirement from three hospitalizations to 1, that there would be an increase of about 120,000 more reportable injuries under this rule than OSHA had been dealing with historically. That is a huge increase. Going from 5 to 3 pushed the number of incidents up by 5 to 10 a year, and now we're looking at more than 100,000 more reports is what OSHA anticipated. We'll talk a little bit about what they saw in year 1 and what they expect going forward, but that was what the rulemaking record projected. Obviously, the biggest impact of this new reporting rule is, you're picking up the phone and calling OSHA a lot more often than you used to. More reports likely means more inspections and more citations. It is extremely rare that OSHA shows up at your workplace for an incident inspection and doesn't leave without citing at least 1 serious violation. I mean, it's 75% chance that they're going to issue a citation in any kind of inspection. That number is even higher for incident inspections. So more reports means more incident inspections and therefore more citations. Another big consequence of the new rule is that OSHA intends to publish these reportable incidents. They're going to put up on their website. I haven't seen that they've started to do this yet, but my understanding is they intend to have a database on their website that tracks Reportable injuries probably includes all the detail that you share in the report, and perhaps even some of the detail that you share after the report that we'll talk a little bit later in this presentation. My expectation is it's like other databases on OSHA's website where it's searchable, sortable, and those who intend to do you harm will be able to take advantage of this public data to further do harm to your company, whether it's a plaintiff's attorney, a union for purposes of collective bargaining advantage, or even an organizing campaign. Perhaps it's the agency itself in additional enforcement activities. The media who might intend to run negative ads or negative media about your company, or your competitors who might use it against you in the context of competing for contracts and business. So the fact that these things are going to be reported publicly has this public shaming element to it that OSHA has been very happy to roll out in other elements in their enforcement program as well. Another component of that here with this reporting rule. So let's talk a little bit about the nuances of those reporting requirements. In particular, a couple of the big ones that we've been surprised have been a little bit less intuitive than we expected, and that includes what is meant by hospitalization and what is included in the amputation context. Hospitalization is, it's not as intuitive as it sounds. It is not a matter of an employee walking through those double doors at the entrance of the hospital makes this a reportable event. It is, in fact, required to be formal admission to the inpatient service of a hospital or clinic for care or treatment. That is what triggers the reporting requirement. Formal admission to the inpatient service, and then after that formal admission, there is medical care or treatment delivered to the patient. So this does not include admission for observation or testing only, and that means even if you spend several hours in the emergency room going through multiple emergency surgeries and getting multiple forms of medical treatment beyond first aid, if at the end of all of that medical treatment in the emergency context, you are admitted to the inpatient service only for observation, that is not a reportable hospitalization. There must be formal admission first and then medical treatment second for it to be a reportable hospitalization. The new rule no longer requires an overnight stay at the hospital to be reportable, but I think that's sort of a difference without significance because it is extremely rare that one would be admitted to the inpatient service and not be an overnight stay, and we'll talk a little bit about why that is in just a moment. OSHA has already recognized in some public speaking, in some guidance about the rule, and in some communications we've had with enforcement folks at the agency, they understand that there is confusion around this admission. What does admission mean? And it means something different in different contexts. It means something different to insurers. It means something different to hospitals and clinics. And it means something different to sort of those of us who are not in the healthcare universe. But OSHA has suggested that the way to conduct this analysis is to focus on inpatient versus outpatient. And that is more widely understood, it's better defined, and it is in a lot of OSHA guidance already, and we expect them to be putting out more guidance that makes this clear that the focus is on inpatient versus outpatient. And this needs to be a formal admission to the inpatient service of the hospital to be a reportable hospitalization. And we had a conversation to make sure that we understood what OSHA meant with one of the senior officials at OSHA on the enforcement side of the fence about this sort of sequencing, about this chronology of injury, treatment at the hospital, and formal admission. And their answer made very clear that it's not just about receiving medical treatment at the hospital in conjunction with an admission to the inpatient service. It's that the medical treatment must follow the admission to the inpatient service. And here's the example that they gave. An employee breaks his leg, goes to the emergency room where his leg is set. He's administered prescription drugs to treat the pain. All of this happens in the emergency room. That's not a reportable event. Likewise, if the employee breaks his leg, goes to the emergency room, begins to bleed out. The emergency room replenishes blood before setting the leg, provides all sorts of prescription medication in the emergency room, and then the patient is admitted to the inpatient service for monitoring because of the blood loss during the after the break and during the surgeries. But he's only there for observation after the admission. OSHA confirmed that that is not a reportable event. I see a handful of questions cropping up here about timing, and we are definitely going to focus on timing as a major element of this. But we want to get through sort of these elements first, and we'll talk about these timing issues in just a moment. So I'm going to turn it over to Lindsay to talk about amputations.
So as Eric mentioned before, amputations are one of the things that OSHA added to this most recent version of the reporting rule. So there are still, although OSHA has put out, some guidance on what exactly amputations are, how they should be assessed, there are still a lot of nuances to the rule that are not completely clear. So overall, what we understand amputations to be is the traumatic loss of an entire or part of a limb or appendage. And it does include both full and partial amputations. And this is an area that there's still some question on, because what we interpret based on the OSHA guidance as a partial amputation is the complete severing, the part is no longer attached to the body at all, of a portion of an appendage. So, like the loss of the top of your finger or the loss of the top of a toe, that would be what we see as a partial amputation. OSHA's guidance has not been completely clear on this yet, but based on what we have seen, what we do understand, this is what we would interpret to be a partial amputation. The rule specifically states that amputations do not include avulsions, enucleations, scalpings, everything provided here. So even though some of these types of injuries could seem like they are an amputation, OSHA has specifically said that these are not included and do not need to be reported under this rule if they occur. One of the most interesting aspects of the amputation part of this rule, and something that we've actually received a lot of questions on, is that OSHA has clearly stated that amputations do include loss of the tip of a finger. And they have also made very clear that this can be with or without bone loss, and have said nothing further than that. So as we interpret it, it could be really any portion of the tip of a finger, which is kind of ridiculous when you think about it in certain circumstances, because this could mean that you have an instance where you lose some small portion of the finger, stitches might not even be required, no sort of medical treatment beyond first aid is required, it's just, antiseptic and a Band-Aid, and yet under the rule as written, this type of injury would need to be reported to OSHA, even though, in those circumstances I just described, they wouldn't even be recorded. But still, it is technically the loss of the tip of a finger, and that would need to be reported to OSHA. And then finally, you'll see medical amputations are also included. So if the injury results in a doctor later having to remove a certain part of the body, that's a medical amputation, and Eric will talk about timing issues in a little bit, but if that occurs within a 24-hour window, it would need to be reported.
One of the really fascinating elements of this rule is this idea that the tip of the finger without bone is reportable no matter what, when things like severed ears are not reportable. It is, and we've seen sort of the extreme where somebody, just a little bit of skin off the tip of their finger, and we've consulted anonymously with OSHA, and they believe that is a reportable injury. And the bottom line on that, and based on some discussions I've had with folks at OSHA, is the reason that they are so focused on that is, at the same time they've changed this rule, there was a very active national emphasis program on amputations. And OSHA looks at that as, even a sliver of skin off the tip of your finger is a sign of a potentially deficient machine guarding or lockout tagout circumstance, that it's a near miss, that next time might be a more severe amputation. I look at that and say, well, all of these things are essentially near misses. I'm not sure why this is being treated differently, but that is OSHA's view. They are very, very focused on amputation-related hazards, and that's why they are sweeping in so many things that I think most of us would not consider to be report-worthy events, but they do, and that's what the rule requires right now.
So beyond just what would constitute an amputation, there are also some really interesting issues just kind of surrounding amputations generally. Like Eric just said, OSHA is really focused on these amputation injuries, and as a result, you'll notice that first bullet there, amputations do have to be reported separately from inpatient hospitalizations. So for instance, if you have a circumstance where the employee has been admitted, you know the employee has been admitted, and so you immediately call OSHA and say, we have an inpatient hospitalization. If it turns out that that inpatient hospitalization results in the amputation of a body part of this employee, then a call must be made to OSHA to report that particular amputation. Even though you've already reported it as an inpatient hospitalization, it must be reported as an amputation as well. And
vice versa, right? If you have an employee who, at the scene of the incident has an amputation, and you call and report that to OSHA promptly, and then later, the employee then is formally admitted to the inpatient service, you have to report that hospitalization separately. You can, if you know both outcomes at the same time, include both in the same report, but the concept is that OSHA wants to hear about hospitalizations and amputations even if they are the same event.
Exactly. And so, there will be circumstances where you might not necessarily know right at the same time, especially information sometimes can filter in at a slower pace. And so, as you learn of these different resulting, results, either an amputation or inpatient hospitalization, that ignites a new responsibility to then report to OSHA. And then there is also a separate reporting requirement for specific types of amputations. And actually the standard, which is the mechanical power press standard, requires the reporting of all point of operation injuries to operators within 30 days of the occurrence. And that report needs to be made to OSHA. So this is good to know if you do have facilities that have mechanical power presses, even if for some reason maybe it didn't occur in that 24-hour time period, you don't need to report an amputation under the reporting rules specifically. This standard in those circumstances would require the reporting of any injury from a mechanical power press, and specifically in this instance, an amputation. And then finally here, the National Emphasis Program on Amputation. So OSHA has reissued and updated that National Emphasis Program. It is, again, another sign of the fact that OSHA sees amputations as a really important focus for them going forward, and is going to make a lot of effort to really follow up with amputation injuries. Specifically, as reissued, the National Emphasis Program does require that for certain employers meeting specific NAICS codes that are provided in the National Emphasis Program, in the write-up of it, that OSHA does perform on-site inspections when it receives a report from those types of employers of an amputation pursuant to the National Emphasis Program. So beyond the inpatient hospitalization, the result of the injury or illness, the incident that occurs, another important thing that employers should consider in determining whether an injury or illness is actually reportable is whether it is work-related. And this seems like, a basic concept, but it is actually, there are a lot of nuances to determining work-relatedness. And I don't know about many, but a lot of injuries and illnesses that do occur may not actually be reportable if we consider whether they are actually work-related. So generally, OSHA has said that anything Any incident that is caused, contributed to, or significantly aggravated by an event or exposure in the workplace would be considered work-related. So it's a very broad category. OSHA takes a very broad view of it. And then there's actually, this geographic presumption that if an injury or illness occurs in the workplace, the presumption will be that it is work-related. And another important concept related to this is that, the employer just needs to take the employee as he or she is. Unfortunately, there's no consideration to a particular sensitivity of an employee in determining, what the injury was exactly that was caused and whether it needs to be reported. For example, if an employee has particularly frail bones and a trip and fall that might not normally injure any other employee results in a broken arm, this makes no difference in determining whether it is work-related and then also whether it needs to be recorded or reported. However, despite the fact that this is a very broad interpretation of work-related, there are instances where an injury or illness would not be considered work-related. Basically, if an injury or illness is solely the result of an employee performing personal tasks, then this would not be considered work-related. Also, if the employee is injured outside of assigned hours, outside of performing their particular work-related duties, then this would also not be considered work-related. And the standard OSHA has applied in assessing work-relatedness itself, and the standard that it would expect any employer to apply, is determining whether an injury or illness was more likely than not the cause or was caused or contributed to from an exposure or an event in the workplace. So that's a really important concept, more likely than not. And again, this is still quite broad. Even one cause, it can be one cause of the injury or illness. If you already have a bad knee or an employee that has a bad knee and they are constantly kneeling down or squatting to perform their duties, and that over time significantly aggravates the knee and causes a more severe injury, that's still considered work-related. One significant exception that we have seen and have come up, during this first year of the reporting rule and determining whether something is actually work-related and thus reportable is when you have signs or symptoms of something that the employee already has, is just signs or symptoms that come up at work, and solely from a non-work-related event, this would not be reportable. And one of the circumstances we have seen this actually in practice is an employee who might have epilepsy. And while at work, they have an epileptic seizure, and as a result, hit their head and cause an abrasion to their head or hit another part of their body, potentially resulting, if it's serious enough, in an inpatient hospitalization. Although technically the seizure occurred at work, it is solely, the source of it is solely the epilepsy that the employee had, completely non-work related, and thus any injury caused as a result of the signs or symptoms of the epilepsy that occurred at work would not be considered work related, and thus that injury that caused the inpatient hospitalization would not be reportable.
There's a good question, a really good question here about what about a heart attack in the workplace? And the specific question is, what about a heart attack while moving material engaged in a labor activity? OSHA has guidance that suggests that OSHA's view is you should report all heart attacks and strokes that occur at work, and OSHA will decide whether we want to look into it any further. I take a different view of that. My view of this is that the rule is very clear that you're only reporting work-related conditions to OSHA. So, going back to the concept of the very strong geographic presumption and the very liberal standard of, contribution in any way of work to the condition, most of those events are probably still going to be reportable, especially if in the question that's asked here, if the heart attack occurs in the context of some laborious activity, I think OSHA is going to expect you to report that. But if you have, very, very compelling medical evidence that it has nothing to do with work, we've seen instances where an employee was, doing an office job, just sitting at their desk, had a heart attack, and we learned, after the event that employee had a history of heart conditions and actually told somebody when they got to work that day that they were feeling ill when they got there. So it seemed pretty clear that this condition was not work-related. That was an instance where we advised that was not work-related, or all indications were it was not work-related, and so we decided that there was not a need to make that report. But OSHA has put out some conflicting guidance on this, right? There's guidance that says report all heart attacks, but then when you read some of the other interpretations related to that, they do suggest that you do need to go through the same work-relatedness analysis. And, it is very hard, certainly if it's a fatality, hard in an 8-hour period of time, or even for a hospitalization within a 24-hour period of time to, reach some effective medical conclusion that it was definitely not work-related. So often these are getting reported, and, you see what OSHA doesn't, they're not going to jump out and do an inspection if they hear the report of the heart attack for the employee sitting at their desk. But if it's an employee working outside in high heat and doing laborious work and they have a heart attack and you report it, I'd say the chances are pretty good they're going to come out and look at that. So it is definitely worth doing the analysis to see whether there is a strong argument to be made that it's not work-related.
Yeah, and actually the standard itself specifies that it needs to be work-related heart attacks. So again, the presumption would likely be, if it happens in the workplace, that it is work-related, especially if there's any sort of strenuous activity going on. But I think the OSHA guidance would support that you need to make a work-related determination first. And again, the time periods that Eric is going to go over in the next slide, those are triggered by determining work-relatedness and, determining the type of outcome that has occurred. So if information is coming in that might affect that determination, that's something to consider as well in determining what the exact period would be for the reporting purposes.
All right. I am so pleased to see all of the questions that are being asked about timing, because timing is in fact been the one nuance of this rule that has resulted in a lot of reports being made to OSHA that did not have to be reported. But also, if they are, run by an attorney, or if you're, very up on this rule, which hopefully all of you will be after today's presentation, that you will know that this is not a reportable injury and saves making a lot of reports that don't need to be made. So there are critical time periods and timing issues that we have learned over the course of this first year. The rule requires that you report within 8 hours of when you learn of the fatality. It's not within 8 hours of the fatality. It's within 8 hours that you learn you have a reportable fatality. So that means, if an employee is working alone on the night shift and is discovered the next morning that the employee has passed away, the 8-hour time period that is triggered is 8 hours from when you learn about that. And it's I say when you learn. The rule is when a supervisory representative of the company learns about the event, that triggers the start of the clock to make the report. So it's 8 hours from when you learn about the fatality, 24 hours from when you learn about the reportable serious injury. That means 24 hours from when you learn that the employee has been admitted to the inpatient service of the hospital, or 24 hours from when you learn that an amputation has occurred or the loss of an eye has occurred. Now, that part is, tells you when you need to pick up the phone, but where the real nuance kicks in is when the result makes it reportable, or when the result achieves one of these reportable criteria. And a fatality, and this is not a new element of the rule, but a fatality, if the employee does not, if the injury does not result in a fatal outcome within 30 days of the incident, that is not a reportable fatality. And that used to be a rule that had some consequence, because a single employee gets seriously injured, is at the hospital in critical condition for more than a month, is in a coma for more than a month, and ultimately succumbs to those injuries and dies, you're outside that 30-day period. There is no obligation to report that fatality to OSHA. That's still the case, but today it is very, very likely that an employee will be admitted to the inpatient service of a hospital during that 30-day period. So you've already reported to OSHA the hospitalization. They're already going to be aware of that incident. So you don't need to separately report the fatal outcome 31 days later, but OSHA is already aware of the event. Where we're seeing the real nuance here, where we're seeing the timing issues really kick in, is that the hospitalization must occur within 24 hours of the incident, and the amputation or loss of an eye must occur within 24 hours of the incident for it to be a reportable hospitalization or a reportable fatality. And so I get another slide here that sort of digs into this a little bit. The most common timing issue that we're encountering is that an employee is not admitted to the inpatient service within that 24-hour period. And the reality of our sort of backwards broken healthcare or health insurance system in this country is that hospitals and clinics are reimbursed by insurers at a higher level for emergency service than they are for inpatient service. So it is very common for hospitals to delay as long as possible the formal admission to the inpatient service of a patient so that they can charge at a higher rate for emergency service. And, you know, regardless of the reason and regardless of the motivation of the hospital or the insurance company, if your employee is not admitted to the inpatient service within 24 hours of the incident, that is not a reportable hospitalization. And we have seen, I've even heard that there are hospitals out there that have as a policy that they will not formally admit a patient to the inpatient service for 24 hours after they arrive at the hospital. And that means if they were injured at work and it took 15, 25, 30 minutes to get to the hospital, and the hospital is not admitting you for 24 hours, that all of the admissions at that particular hospital are occurring more than 24 hours after the injury. And that means that is not a reportable inpatient hospitalization. So really interesting development there. The other thing that we're seeing, not as often, but enough that it's worth talking about, is that very often a medical amputation, and Lindsay already talked about how medical amputations count, that is a reportable outcome, but it's only reportable if that happens within 24 hours of the injury. So there are the injuries that occur at work where the injury itself is part of the person's finger or some appendage is lost in the event. That's sort of the obvious reportable incident. But there are others where the injury is a crushing injury, or it's a bad laceration that becomes infected. And after several days at the hospital, then medical amputation is done. That would not be a reportable amputation because the amputation did not occur, did not result within 24 hours after the incident. That may still be reportable as a hospitalization, but we've also seen several examples of the employee who reports to the hospital in the emergency service and has a bad crushing injury or something like that and is released outpatient but told to come back the next day or 2 days later to get an outpatient medical amputation procedure to facilitate better healing. You know, they might shave the bone, or they might make cuts to a part of the finger to allow for room for the healing process to occur. And those medical amputations done outpatient more than 24 hours after the injury, the initial incident, are not reportable amputations. And we've seen more than enough examples of that to know that this is something to pay attention to and to think about before you pick up the phone and call OSHA. The other thing that we're seeing, and we've already talked about this a little bit, is that there is substantial emergency medical treatment provided in the emergency room, followed by an inpatient admission for observation only. So this timing issue is more about sequencing than the amount of time that's passed. If you're getting substantial medical treatment, but it's only in the emergency context, and then admitted only for observation, that is not a reportable hospitalization. So very interesting stuff. I'm going to take a quick peek at the questions we've seen here to see if we've addressed them just by the natural course of these slides. Yes, I think that's the exact question about finger becomes infected, resulting in amputation 4 days later, not reportable. It may be reportable as a hospitalization, like I said, if they're at the hospital receiving medical treatment during that period of time. And if that admission occurred within 24 hours. Who needs to be notified of the injury for the time clock, 8 and 24 hours to kick in? The rule is that we've heard OSHA say and that we've applied ourselves is that it has to be any supervisory employee of your entity, of the entity that is responsible to make the report. If a supervisory employee learns about that, that starts the clock. So we will talk a little bit about who is responsible to make those reports in just a moment. I did want to talk a little bit about OSHA's web portal, and fairly timely, I think it was about a month ago, OSHA finally went live with their online web portal for reporting. And OSHA was very excited about this. They did something very similar in the context of whistleblower complaints. OSHA introduced a web portal for employees who feel that they've been retaliated against to lodge their complaint about retaliation or other adverse employment action for taking a protected action, and saw a huge surge in the number of whistleblower complaints they received. We're in the age of the iPhone and the iPad, and everybody is very comfortable on that, and they play around with that all the time, and they see, hey, look how easy this is, and it's almost like a video game. I get to report my whistleblower complaint to OSHA, and they saw exactly what they were hoping for, a big surge in reported whistleblower activity. So OSHA thought, hey, we could do the same thing for this injury reporting, make it easier for employers, and maybe cut down on some of the underreporting if we make it convenient and accessible for employers. I have been cautioning my clients that I don't think it's a good idea to use this web portal. And there's a few reasons why. One is that you are committing in writing to a version of this incident at a time where I think it is very premature to be doing that. If this is a fatality event, you're doing this within 8 hours. If this is a serious injury hospitalization, you're doing it within 24 hours. And I don't know too many employers who have completed their incident investigations for serious incidents within 8 hours or within 24 hours. And yet you are required in this reporting process to identify more or less what caused this incident. What was this incident? What was the outcome of this incident? And I just think it's premature to commit in writing to a version of that. And I think that's particularly important because of how these are going to be used. We talked already about how they're going to be published online. They're going to be taking your words and just smacking them right up there on OSHA's website for all the world to see. But also, they're going to be used in the context of an inspection by OSHA if there is one. They could be used as an admission by the employer about some major element of an enforcement action that may follow this reported injury. They can be FOIA'd and accessible to a plaintiff's attorney and used in a personal injury or wrongful death lawsuit against you. So putting it in writing, those are your words. You're bound to them for the rest of the process, and I just think it's premature to do that. The other thing I've noticed is, and I went through and sort of did a report through the web portal up to the point of hitting submit, and realized that they were asking a lot more questions on the web portal than they do when you make the report by telephone. When you make the report by web portal, they're essentially asking all the questions that they may be asking you in a rapid response investigation request, which we'll talk about later in this presentation, what happens after you report. Many are not getting inspected, but instead are getting this rapid response investigation. This web portal really tracks that RRI process a whole lot closer than the telephone report does. The telephone report is very basic stuff. So I think that if you're using the web portal, you're providing more information, you're committing in writing to something that I don't think you should be doing, at least at that early stage. And then there's also, I think, a real risk of electronic security. you're providing some pretty personal health information about your employees on a government website that I lack some confidence in, as we've seen with other significant information technology projects for this administration over the last few years. So I have some concern about the real ability to secure that health information, and you could be responsible for that, or at least put your employees in a bad situation by doing that. So I'm going to turn it back to Lindsay to talk about some of the final logistics of the reporting rule, and then we'll talk about what happens next.
So we've also actually received some questions on who actually has to make these reports. And these come up usually at work sites where you have multiple employers who could potentially have a relationship to the injured worker. You have multi-employer work sites where there's literally, multiple different employers on the site who are directing the work of the employees, who are, making assignments and conducting these projects. And then you also have work sites that are using contractors or temporary workers where the relationship might be a little bit fuzzy. And so what OSHA has said in these circumstances is that the report, similar to the responsibility to record an injury or illness, the report must also be made by the employer that has supervisory authority, day-to-day supervisory authority. And in kind of further explaining that, OSHA has stated that this is the employer that controls the conditions presenting potential hazards and those that direct the workers' activities around and exposure to those potential hazards. So the idea being that the employer that is controlling the exposure to the hazard, how often the employee might have to be around the hazard, what they might have to do, when they're around the hazard, that employer is the one best suited to not only record the injury, but also to report the injury. So in that case, like I said, it should be the person that supervises the day-to-day activities of the employee. Next, just a quick review of the exceptions to the reporting rule, the types of injuries that do not actually need to be reported to OSHA just right off the bat. These first two are actually specifically in the standard. They are, if a motor vehicle accident results in a fatality or inpatient hospitalization, or if a fatality or serious injury occurs on commercial public transportation, then the employer does not need to report those types of injuries. And then the last two.
Those are, by the way, if they're work-related, they can still be and likely still are recordable. They're just not reporting events. Right,
exactly. And then the last two on here are ones that Eric had addressed earlier, but they are very important. And so I think it's worth just reiterating real quickly that, again, if an employee is admitted to an inpatient unit, but it is solely for the purpose of diagnostic testing or observation, then this is not a reportable event. Even if medical treatment was received prior to that admission, the admission itself is just for observation, then this is not going to be reportable. And then also in the circumstance where you have outpatient care, emergency care, where there's no actual formal admission into the inpatient service, these types of injuries and illnesses are also not going to be reportable. And then finally, this slide just kind of gives you an overview of what exactly has to be provided in the report that you make to OSHA. Most of these points are very straightforward and basic and not likely to be particularly problematic. The one that we see that, employers should be very careful about is the brief description that they provide to OSHA. You really want to take some time before making that report. And obviously, these windows are not super long, but it's worth it to take some time before making this report to just carefully think out exactly what you want to say as far as the brief description. Because, even if you follow our advice and don't make this, this report online, you do it verbally over the phone, it's likely that whoever's on the other end is going to be taking some notes on this. So it's important to just make sure it's carefully thought out and planned before the report is actually made.
And a good frame of reference for this brief description of the work-related incident is the same type of brief description you might provide on your 300 log. I mean, that basic, one sentence, this is what happened, this is the part of the body affected, and this is the instrumentalities that were involved in the incident. Same thing you would include in the description column of the 300 log. All right, so now we're going to talk a little bit, actually let's address a couple of questions that have come in here. An interesting question here about now that OSHA has introduced the web portal, are they likely to eliminate the telephone reporting option? I really doubt it. I feel like that would be one of these situations where the federal government can't guarantee that that anyone has access to, or that everyone has access to web-based technologies, even though really everybody does now. I think it's very likely that they'll maintain the telephone option. Certainly right now, the rule as proposed, listed all three of those reporting options. So they would have to go through a rulemaking really to eliminate the telephone option. And I just don't see it happening because of the idea that presumes that everybody has the same technology or same access to technology. Another really good question that we've been asked a few times is loss of vision considered loss of an eye, and it is not. The loss of an eye component was kind of a peculiar thing to slip in. It was not part of the original proposed rule, but it became part of the final rule because of some questions and comments during the rulemaking process where it was trying to figure out whether a loss of an eye was considered an amputation. OSHA believed that it was, but since there were enough questions about that, they slipped it in as a specific type of injury. So the focus there is on the physical loss of that part of the human body as opposed to the functionality of that part of the body. We got a question here that there was a worker on a lawnmower who was working alongside a road when the vehicle struck and killed him. Was that a reportable fatality, or does it fall under the motor vehicle exception? That's an interesting question. I mean, there is a carve-out to the motor vehicle exception for work that's being done in a construction zone, and the purpose for that carve-out is the idea of a person who is working on a public road doing construction work and is hit by a pedestrian or by another construction vehicle. They want that to be reported because that has perhaps possible implications of whether you as the employer have done enough to protect your employees working in that environment. So they want to hear about that. This sounds similar to that. And I think OSHA would look at that and say, this is not a motor vehicle accident as it relates to your employee. This is your employee working on some company-powered industrial vehicle. I think I'd have to look at that more carefully, but my instinct is that probably is reportable. But we could get back to you after this webinar if that's something you're interested in. The last part of the presentation, we wanted to focus on what happens next. What's OSHA going to do with all of these new reports that they're getting as part of this new rule? And David Michaels, when he was announcing the new rule, made this statement, which was a pretty good sign to me, which is what I expected anyway, as to what OSHA's plans are with all this new data. And the idea is that because of the new reporting rule, OSHA is now going to receive crucial reports of fatalities and serious injuries that will enhance OSHA's ability to target our resources to save lives and prevent further injury and illnesses. So the thought here is that OSHA is going to use this data to target enforcement resources. This is a way for OSHA to know where they need to visit to conduct enforcement inspections. So what are the circumstances where OSHA is going to conduct enforcement inspections? They have broken it out. There's actually a directive, a communication out to the regions and area offices about how to determine whether to inspect or not. And they broke it into three categories. And the first category was mandatory field inspections. And it's interesting because they say mandatory, but they don't actually do 100% of these events are not necessarily inspected, but they are more or less expected to be inspected. A mandatory inspection for fatalities and inpatient hospitalizations involving 2 or more employees. We have seen quite a few examples of heart attacks and strokes and things like that being reported that OSHA is not inspecting because they reach, generally the same conclusion that that we probably would if we were involved in the decision that it was not really work-related. So there are some reported fatalities that are not being inspected, but generally speaking, most are. I think it's like 85%. We've got some data on that. Inpatient hospitalizations of 2 or more employees are, according to OSHA, certain to be inspected. Cases involving youth workers are, they say, mandatory inspections. If the report is coming from an entity that has a history of the same or similar types of events, or an entity that has a history of OSHA violations of the same category related to the report that's been made, are going to be inspected. Likewise, if the report relates to a national or regional or local emphasis program, for example, if you report an amputation and there is an Amputations National Emphasis Program, they are going to do an inspection of that incident. Likewise, for excavations and in the primary metals industry, all of the areas where they've got these active emphasis programs, they're going to come out and take a look. Other categories, if the report comes in about a serious injury for an employer who's qualified into OSHA's Severe Violator Enforcement Program, they're going to give you a visit, but you're probably already being inundated by inspections because you're in that program anyway. And then anything that OSHA characterizes as an imminent danger, obviously they'll inspect that as they have done over the life of the agency. The other 2 categories are those where it's possible they'll do an inspection, but it depends on some of the characteristics of the reported injury. And these questions here are the factors that OSHA is considering to decide whether in the area director's discretion they will do an on-site inspection. And it's things like, is the condition still present in the workplace? Were temporary workers involved? We talked about emphasis programs in the last slide here. We know that OSHA has their temporary worker initiative. It's not a formal emphasis program, but if temporary workers were involved in the injury, very likely that OSHA is going to come out and do an on-site inspection. Does the employer have prior OSHA inspection history? Not necessarily willful or repeat violations, but at least a lot of attention from OSHA or a lot of serious violations. They're more likely to come out. Is there a related whistleblower activity around the report? If so, they're much more likely to come out, and you see here the list of those circumstances. Category 3 means it's not a fatality or hospitalization of 2 or more employees, and the factors that OSHA considers in Category 2 result in the area director exercising the discretion to not do an on-site inspection. OSHA will follow this third path, and this third path, probably you've all heard about it by now, is the rapid response investigation, a brand new invention by OSHA as a way to triage the flood of new reported serious injuries that OSHA is receiving because of the change to the new rule. OSHA is still a small budget agency, only a couple thousand employees around the country. They don't have the ability to inspect every workplace. They don't have the ability to inspect every reported serious injury, certainly if those reports achieve the numbers that OSHA anticipates. So they invented this process called the rapid response investigation. And it is, if you've been dealing in the OSHA circles for a long time, you have probably seen over the years the phone and fax process in the employee complaint context. An employee makes a complaint to OSHA about a workplace hazard. If that workplace hazard is really serious or it's something that OSHA is really interested in, like amputations and things like that, OSHA is likely to inspect. But if it's something that OSHA is not real hot and bothered by, and it's not something they're really focused on, they will send you, they would call it the phone and fax process. They'll fax you a letter that says, we've received this complaint. We would like you to investigate, you the employer, to investigate the complaint and respond to us in about a week as to whether the complaint is legitimate, and if it is, what you've done to address the circumstances of the complaint. And if you give an adequate response, OSHA will not initiate an on-site inspection. This is basically the identical forum for reported injuries as opposed to reported complaints. OSHA will contact you, and they will fax you a letter that is this rapid response investigation request letter that attaches this image on the slide here. This attachment A to the letter will be this quote-unquote non-mandatory investigative tool. And it's true that you don't have to use their form, but they are expecting you to respond, and they're expecting you to address the issues and the questions that they raise in this form. And the idea here is they're asking you to conduct a root cause accident investigation, document the findings and any corrective actions that are recommended and taken. They ask you to post the letter and to post your response, and to provide a copy of the letter and your response to a union if it's an organized workplace, and or to the safety committee if there's a safety committee. The rapid response investigation, if you have an adequate response, means OSHA is not going to come out and do an on-site inspection. If they don't like your response, they will either send you or call you and ask you some follow-up questions, and encourage you to change your response. For example, if you've identified the only cause to be employee misconduct, they may come out and do an inspection. They hate that response. Or they may encourage you to dig a little bit deeper and try to find the management cause or the management breakdown that allowed the injury to occur. Or if you don't identify any corrective action, they may contact you and ask you to supplement your response. Or they may just come out and do an inspection if they don't like your response. And so you're required to conduct, well, non-mandatory. And the people at OSHA that I've talked to have said, look, we're giving you an opportunity to do this investigation yourself. If you don't want to do it, we'll do it for you. And what that means is they'll come out and do an enforcement inspection if you don't do it.
So now we're just going to take a little bit of time to go through some of the data that we've seen from this initial year, fiscal year and calendar year that this rule has been in effect. So in fiscal year 2015, OSHA received approximately 12,000 reports. So this is 12,000 reports in 9 months. And of those 12,000 reports they received, 35% of them resulted in inspections. So pretty significant number. You have almost 1/3 of these reports that are resulting in inspections, which with 12,000 reports being made would be around 4,000 inspections that are resulting from this new reporting rule. Another significant fact is that 20% of these reports actually didn't need to be made. 20% were not work-related, or they were not actually covered by the requirements of the new reporting rule. And so in these instances, OSHA doesn't really take any further steps. But we think this percentage is also significant because it shows that there are a decent amount of reports being made that really don't need to be made. And with the fact that so many of them are resulting in inspections or at least this follow-up information, it indicates to us that it needs to be a very careful evaluation to determine whether things are actually reportable.
Right. These are the people who did not call us before they made the report, so I'd encourage you to do that. The other thing is there's a lot of folks out there, and we have this discussion all the time, where somebody says, all right, I understand what you're saying, that this is not technically required to be reported, but we intend to make a courtesy report to OSHA anyway, because it was serious. OSHA may hear about it anyway. And we don't want them to think we're hiding anything from them, so we're going to make a courtesy report. And in my opinion, there is no such thing as a courtesy report. I assure you that OSHA will not show you any courtesy for having done this. And they're not going to retaliate against you for not reporting something that was not required to be reported. So to me, there's no such thing as a courtesy report. Don't do it. Do the analysis. If the conclusion is that it's not reportable, my advice would be to not make the report.
And then finally here you'll see that the biggest chunk of the reports that were made, OSHA utilized that rapid response investigation tool to follow up and get some additional information. And then, from there, we don't really have the statistics as far as the follow-up for the RRIs, if there were any inspections that resulted from that. But I think we've seen overall that a lot of them have not resulted in an inspection where, the information that OSHA has requested is actually provided.
Yeah, so I've polled the the area directors that I know over the course of the last year to talk about, what are the circumstances where you're using RRI versus an inspection, and what are the circumstances where you do initiate an inspection after getting an RRI response. And I'll talk a little bit in our sort of last slide about best practices, about what I'm hearing from the area directors, because there are definitely circumstances where OSHA is going out and starting an inspection after getting your RRI response, but I got pretty consistent responses from the area directors about when they do that. So I'll share that information with you.
And these next few slides are tables of statistics recent statistics that we've seen on the reporting rules impact in 2015 from data collected by OSHA. So this first chart shows the approximate numbers of each type of injury and the percent of those reports that resulted in an inspection. And based on OSHA's follow-up criteria, it's not really surprising to see that the fatalities, by far resulted in inspections. Around 87% of them resulted in inspections, on-site inspections from OSHA. The amputations, however, I think are a pretty significant and important thing to see, as far as the fact that you had around 2,644 amputation reports, and over half of those reports did result in an inspection. And again, we talked about, the National Emphasis Program. There is obviously this very strong focus by OSHA on amputations. So with that in mind, the 58% might not be as surprising, but this is a really significant number for, just a report of a serious injury. So this next table breaks down the statistics of serious injuries, which are those that are resulting in inpatient hospitalizations and amputations by the industry sector. And you'll notice that most of the reports that are being made, most of the injury reports, are coming from the manufacturing industry. Actually, by a significant amount, it's more than double, the next industry sector, which is construction, at almost a third or a little over a third of the reports, the injury reports that are being made. And the next from there, you have construction at around 17%. The rest of the industry sectors are largely within that 0 to 10% range, but an interesting, perspective nonetheless to see exactly how these injury reports do break down by industry. And then finally, this last chart shows the top 10 industries, a little bit more specific, the characterization of the industry. And it shows the number of reports that were made, as well as follow-up inspections that occurred because of those reports. And you'll see that a lot of these industries actually had around that 30% range where they're making these reports, and then about a third of them, over a third of them, are resulting in on-site inspections from OSHA. And you'll notice that actually roofing contractors specifically, over half of those injuries and illnesses that were reported by employers in the roofing contractor industry did result in an inspection, in an on-site inspection.
All right, so I thought there was some really interesting data in there, and I'll point out a couple of things that I thought were most significant. There was a question here about, is this information available on OSHA's webpage? It's not. This was provided to us by a contact that we have at OSHA. We told him we had this webinar coming up, and we'd love to be able to share some data with everybody, and he provided this to us. So it's breaking news. This is, as far as I know, first time publicly available, that data. OSHA is working on, they announced they're putting together a report about the first year of the reporting rule, and I think that's where that data comes from, is their process of putting that report together. In any event, a couple things that I thought were really interesting there was I was stunned, frankly, at how low the number was for reportable injuries. OSHA projected, and they still project, and you'll see on this slide that in OSHA's 2017 budget request, they're still floating this 117,000 estimated reported injuries expected under this rule as a need for increased budget, an increased number of full-time employees to handle the flood of reports. I mean, it is a flood of reports. Even 12,000 is, triple what they received in the past, but they were expecting a magnitude of, hundreds more than they received in the past. But that was the thing that jumped out to me, is how low that number was.
Well, and just to go off of that, one of the things that I thought was really interesting too is OSHA, had this projection, this huge projection of the amount of reports they would receive. And obviously we didn't meet that amount. And so OSHA's automatic reaction is that things are being extremely underreported. But if you look at the data, I mean, 20% of the reports that were made were actually not reportable incidents. So I thought that was really interesting as well.
Yeah, and that's exactly right. And we make that point here that, OSHA is expecting over 100,000 reports. I think OSHA is probably very surprised. I know I was extremely surprised by the impact of the 24 hours to formal admission to the inpatient service, what an impact that's having on reportable hospitalizations. So maybe they're starting to realize that this is not necessarily the result of underreporting. But what I started to see at the end of 2015 was willful violations related to failure to report. OSHA hears about the injury from the employee or from the emergency responder or from the media, and they get out and do an inspection, and you haven't reported it, or you reported it late. They're now starting to issue big dollar violations for that, because I think they're trying to educate industry, say, you guys are not reporting. We're expecting much higher numbers. Obviously, there's underreporting happening, so we have to educate industry. And the way OSHA educates industry is by poster child enforcement, and we're just now starting to see that happen. The other thing we have definitely seen is more incident inspections. And what's interesting, if you joined us last month when we talked about sort of inspection data generally over 2015, is there was a dip in the total number of inspections that were done. So if there's a dip in the total number of inspections that were done, but there are more incident inspections, then that means there are fewer programmed inspections. And I saw a report about that recently where I believe programmed inspections dropped from like 55% to 45% last year. And that is a really interesting development to track here. This means OSHA is moving off of inspections under some of their emphasis programs and becoming more of a reactionary agency like they used to be. During this administration, we saw the use of the emphasis program grow exponentially, and for the first time ever, more than half of OSHA inspections were programmed inspections. And that has changed, and I think that trend will continue to change to be more reactive incident inspections as a result of that. And I think that might have some impact on the number of repeat violations that OSHA has been issuing and lots of other areas. So we'll talk now, final slide, I promise we're not going 2 hours today, on 5 reporting and rapid response investigation best practices that we've gathered over the last year. And some of these we've talked about already. The first one is, let's really make sure that we're dealing with a reportable event. And that means research the circumstances of the hospitalization, if it's a hospitalization report. Find out precisely when was the employee admitted to the inpatient service. Find out about the chronology of medical treatment. Was there medical treatment both before and after the formal admission? Was the amputation, did it occur within 24 hours? Was it, was it an outpatient procedure? All of these things, you really want to, don't just take on its face that the employee was carted off to the hospital means you've got to pick up the phone and call OSHA, dig into it, and don't make a report that you're not required to make. Again, talking about the web portal, pick the old-fashioned, pick up the telephone. If you still have a telegraph machine, I wouldn't use that either. I would stick to the telephone, make your reports verbal. Don't use the web portal. Don't use the telegraph. Don't fax or email anything to OSHA. Use the old-fashioned telephone. For the rapid response investigation, this is where I've learned a few things about dealing with OSHA over the years and dealing with some of the area offices over the last year about things that they prefer and things that are keeping them out of your workplace. The first one is, and I know that some of my brothers and sisters of the OSHA Defense Bar take a different view here, but after a lot of debate here within my OSHA team at Conn Maciel Carey, our conclusion is that the best strategy is to use OSHA's non-mandatory investigation form. The RRI form, they have that attachment A, the non-mandatory root cause investigation document. And the reason that we're recommending doing that is that it makes it a lot easier for the recipient, the duty officer at the area office, to confirm that everything that they're asking for, all the information that they require, is in there, because they know exactly where it is. They know where on that piece of paper the box for corrective action is, and they know where the box for the description is, and they know where the box for the employee's logistical or demographic information is, and they can go through more or less a check the box exercise and say, well, it's all here, we're going to close the file on this one. If you use an alternative form, it may well include all the right information, but it means that the reader has to give it a little bit more scrutiny to find the information that they are expecting to find. And a little more scrutiny might mean they don't like your answers as much, or they realize they don't like your answers very much and decide to take a closer look, make a follow-up request, or maybe do an investigation. So I like the idea of using their form itself. In the rapid response investigation response, do not list employee misconduct as the sole cause of the incident. And if you are listing multiple causes, I would not make it the first cause that you list. This is the one that makes the hair on the OSHA inspector's neck stand up. The area directors hate it. They don't like managers blaming the employee for the injury, even if that's what it is, even if there's really no other way to effectively describe it. Try to be creative and try to find a way to include some other potential cause of the incident, of the injury, and list them both. I'm not recommending that you leave employee misconduct off, because you want to preserve that defense. If it's legitimate and the incident was caused by an employee not following your policies, you want to include it because you want to preserve that defense if you do get an inspection and you do get a citation. But don't list it as the sole cause, and don't list it as the first cause, to try to avoid that, sending up that red flag that might trigger an inspection. And then the final thing is, be sure to include at least one corrective action. Even if this was purely employee misconduct and there's nothing that you can conceive of that you could change from an engineering standpoint, from a physical standpoint, put something in that box, whether it's refresher training or counseling or something like that. You want to have something in that box, because if that box is empty, you're much, much more likely to have an inspection than you otherwise would. And so we have come to the end of this presentation. I do want to encourage everybody, you've probably heard me encourage this before, but please check out our relatively new blog, the OSHA Defense Report, www.oshadefensereport.com. It's already populated with, I think, 30 or so pretty good articles. We're getting a lot of great feedback about it. If you've got ideas or things you'd like to see us write about, send us an email or call and give us some ideas there, because we want this to be valuable for you all, but definitely more than anything, we want you to read it. I'd love to know that someone other than my mom is out there reading this. She thinks it's wonderful, so I'm sure you will also. So let's see. I think we might have some more questions coming in.
And just, on our blog, I have seen a few questions regarding, where there will be resources about all of the things that we just talked about. Some of the blog posts that we do have already on there, you can reference those. I know we have one about amputations. I think that we have others on the reporting rule more generally, so you can definitely reference those. And we will be posting more and more information. We have all of this new data now. We'll be posting more on our blog, so that's always a quick reference that you can use.
Yeah, we do have a few more questions coming in here, and let's go through some of these. There's one about does OSHA have access to insurance records to see the medical services actually offered for an event? And it's a great question, and it sort of depends on what state you're in. Let's put it this way. If OSHA initiates an inspection, they will have access to those records because they have subpoena authority, and they're going to be asking you for your 301 incident report and maybe your first report of injury. And if they feel like there's something that's not quite adding up between your report and what they're seeing in the field, they're probably going to dig into more detailed medical records and ask for those from you, or possibly from the place where treatment was given. I do know that there are some states that have sort of a state-run workers' comp insurance program that OSHA does without asking you for it, have access to those records. I think Missouri maybe even has an inspection program where they are looking at workers' comp reports that are being made and choosing from those reports a subset to do inspections for. So sort of an emphasis program focused on workers' comp data. So they do have access to that information, at least in state-run insurance programs. But they can get it from you if there is an inspection, or if they just ask for it, in the context of one of these RRIs. You'd have to make a determination whether you want to respond or risk having an inspection be initiated. Lindsay talked about access to fact sheets and other resources like that. Generally, you can find those linked in our blog posts. But OSHA does have a whole page on their website dedicated to this reporting rule, and it's pretty good. They've got a flow chart that sort of walks you through the reporting rule. I don't think it's not as good as what you heard here today. It doesn't get into the nuances. Like, they're not trying to find ways to have you not report. So if you want to know what the rule, like to a precise level, ask us, don't ask OSHA, but they do have good resources out there about that. A really great comment here from an attorney I know who says that along with the RRI form, there is a certification of posting form. And the idea here is that OSHA is asking you to post the RRI request and to post your response. And the reality is the law does not require that. This RRI mechanism is a neat little policy that OSHA has implemented. It's a neat tool that they've rolled out. It is not something that's been created by regulation. It's not something that Congress mandated by legislation. So OSHA has no authority to actually require you to post this. But I will tell you that the advice that I'm generally giving about posting is the same as I'm giving about using OSHA's tool, using the non-mandatory investigation tool, or in general, responding to the RRI at all. I look at this as sort of a gift, right? OSHA is saying, you do the investigation, and if you don't, we will. And if we do it, you're going to get cited. So my thought here is we don't have to post, but if we poke OSHA in the eye about not posting, that may trigger an inspection. So the comment here from one of the participants today said that his company has been successful so far in simply stating in the RRI form that the letter was posted rather than using the certification letter, and really maybe even choosing some careful thought about where the letter is posted. It doesn't say where it's required to be posted. It's not like a citation that has to be posted in a certain place where employee notices are typically made. This RRI form, it's not required to be posted at all, so you can post it perhaps in a different location. So I'm seeing from employers some creative thinking around that requirement or non-requirement, such as it is. I'm seeing a question here about, can you discipline an employee for misconduct that resulted in an injury? And the answer is yes. And in fact, I generally encourage employers to implement a very effective discipline program generally. And anytime you catch an employee violating one of your safety policies, discipline is appropriate. If you are only disciplining your employees after they're involved in an injury, the only violations of your safety policy that are being disciplined are those that result in an injury, you can very likely find yourself facing a retaliation claim. And OSHA has gone to great lengths to try to avoid policies or try to eliminate employer policies and programs that result in underreporting of injuries by employees. And this is one of the categories that they very specifically looked at and said, listen, if you're only disciplining employees when they get hurt, that discourages employees from reporting that they got hurt. And if that's your policy, we're going to try to enforce that under 11C and say that that's a retaliatory conduct, and we don't like it. So I think discipline is incredibly important. It is an incredibly valuable piece of evidence that you're OSHA defense lawyer needs to defend on an employee misconduct ground, but you must apply that consistently whenever you see violations of your safety policy, not just when an employee gets hurt.
The other thing I would say too is you want to apply it consistently. You want to make sure that you have good documentation of it. So if you do, implement any sort of discipline, just make sure that you are specifically abiding by the policy, that you document that you are specifically abiding by the policy, what your process was, how you chose the discipline, and just make sure you have that for your files just in case there is any sort of attempt to file a retaliation claim.
Yeah, so another question here about an employee working on a motorized vehicle, here in this case a mower, and a four-wheel vehicle, industrial vehicle, and is struck and killed by a car that left the roadway. It is not considered a motor vehicle fatality. This is, again, some of the nuances of that exception that I want to look at a little bit closer. But my view of this is, OSHA's saying a motor vehicle incident that occurs on a public roadway is not something that they need to hear about because it's a DOT issue. It's, just a general, motor vehicle incident. Things that are not traditional motor vehicle incidents, I think, are things that they do want to hear about. So if you're off-road and you're doing work off of the public roadway and you are struck by somebody who is also off the roadway, whether they were supposed to be or not, I think that is likely something that OSHA wants to hear about because I think that's akin to the construction zone type of incident. But I would want to look at that more carefully and see if there's anything in the preamble to either the old record-keeping rule or these new changes that shed some light on that for sort of the non-traditional construction activity and how that would apply. But my instinct there is that would be considered a reportable incident because it's not a traditional DOT motor vehicle incident. That's my instinct here without looking at any more guidance on that. I think that's all the questions that we saw coming in through the chat box there. But if you have other questions after today, I won't insult Lindsay and group her in this category, but hopefully you can tell I'm a huge OSHA nerd. I love this stuff. I love talking about it. I love hearing about what you're experiencing out there in the field and things that you've done that have worked effectively or things that you've done that haven't worked effectively so that we can learn from that. So please don't ever hesitate to call, shoot me an email, and let's talk about some interesting OSHA stuff. And I hope that you can all join us next month or for the rest of the year for our monthly webinars in the 2016 webinar series. We're having a lot of fun here putting these programs together and talking with you all every month about these issues, and look forward to doing it over the course of the rest of the year. Thanks for joining us today, and we'll talk to you soon.